7:43, the John McComb Show. It's time for a Boughton Law segment. Boughton Law, CKNW's on-air legal analyst for 2015. They join us on air to give you the lowdown on legal solutions in business and in life. They also join us to explain the legal implications behind some of the biggest stories we cover. What we talk about on the air does not constitute legal advice. This morning, we're joined in studio by Saba Naqvi. She is an immigration lawyer with Boughton Law, and we're going to talk this morning about the ins and outs, the nuts and bolts of hiring foreign workers. Nice to have you in our studio. Nice to see you.
Great to be here, John.
Tell me about what businesses we hear about. When we hear about foreign workers, it's all not always, but it's sometimes there's controversy around it. But it is a very, very established way for businesses to fill the gap of skilled workers. So take us through what businesses in BC use foreign workers.
Well, John, there's a variety of businesses that use foreign workers, and it ranges from the business sector to the trades and even to sales and service sector. And the BC government has put out in its labor market outlook that in the province of BC, there's going to be about 1 million job openings through to 2022. And
so we have to look outside our borders to fill those positions.
Exactly. It's predicted that about 1/3 of those jobs will come from outside of BC, and that includes outside of Canada.
And so what do businesses, let's start at the beginning, what do businesses have to think about? What do they have to do when considering hiring foreign workers?
Well, when considering hiring workers, what they really want to do, number one, is, obviously look at the Canadians first. And that is the federal government's, main goal is to make sure that Canadians are looked at first. But there's also a balancing. There are certain international mobility agreements that make it somewhat facilitative for international individuals to enter Canada. Like, for example, under the North American Free Trade Agreement, NAFTA, if you have a Canadian engineering company who wants to hire an engineer from the U.S., there's a process that's relatively easy, and that individual may be able to get a work permit at the border. So there's a balancing between those agreements and then the more complex labor market impact assessment process.
When I first came to Canada many, many years ago, I showed up at the border and essentially applied for landed immigrant status. And the immigration guy pulled out this big book, and he said, "What do you do?" I said, "Well, I'm a radio announcer." And he opened this big book and paged through it and kind of ran his finger down the list and says, "Well, says here we don't need any radio announcers," and sort of closed the book. And I thought, oh my gosh, this guy's not going to let me in. Well, he did. But how do you know that there are no Canadians who are able to do the job? I mean, what does a company have to go through to prove that?
Yeah, and that's an excellent question. And basically what the Temporary Foreign Worker Program requires is that employers in most circumstances need to go through recruitment for Canadians locally. So they need to advertise in 3 sources, such as Service Canada's Job Bank, websites like monster.ca, or, trade publications or media sites. Like, for example, the tech industry regularly recruits on Tech Vibes, for example.
Right.
So they have to post the ad for a requisite period of time, which is about 4 weeks, and that ad has to stay in place. And new requirements actually require the employers to show all of the Canadians who applied for the position, as well as exactly why they were not qualified.
Wow. So those are pretty significant requirements. And are those new?
It's kind of been evolving over the past few years. Back in the day, the requirements for ads were less burdensome. It used to be a 3-week time frame, and then the ad did not have to stay in place until the application was decided on. Now it's 4 weeks, but most recently they made even more stringent requirements with respect to fees, for example. It used to be no fees, then it transitioned to a few $100s, and now it's actually $1,000 per applicant. So that can be, expensive. Like if a Canadian employer has a huge utility project going on and needs to hire a lot of foreign workers, $1,000 per applicant can be quite costly.
So that employer really has to want to get a person or get some people into Canada to do the job. I mean, it's not just, let's go hire some foreign workers. There's a lot more to it than that.
Absolutely. And I mean, it's a lot easier for an employer to hire a Canadian. And so, they really have to undergo a lot of effort to get a foreign worker into the country.
What about eligibility? I mean, how does the government know or decide who's eligible and who isn't, and whether their skills are applicable to Canada?
Well, they have what's called the National Occupation Classification. And so if an individual has a certain profession, there's guidelines as to what that individual requires in terms of education and experience. And also, they look at, the interesting thing is that the temporary foreign worker program and the LMIA process, the labor market impact assessment process, requires each individual to have those specific skills, and it doesn't necessarily account for the unique person who's self-taught, who might be brilliant but doesn't have the schooling. So that program does not necessarily facilitate the special cases, so they are quite particular in what is required.
I think that's actually why they let me into Canada, was the brilliance exemption.
Right, exactly.
No, not really. We're talking about the foreign worker program and getting down into the nuts and bolts of hiring foreign talent with Saba Naqvi. She is with Boughton Law. This is one of our Boughton Law series segments, which we do time to time here on CKNW. We'll continue and ask some more questions and dig out some more information. Coming up next here on the John McComb Show. Nice to have you with us this morning. Right now, though, we are talking about, the ins and outs of hiring foreign talent, foreign workers, with Saba Naqvi. She is with Boughton Law, and we're doing one of the Boughton Law series segments that we do throughout the year here on CKNW. So how difficult is it to get people, because I hear when people come to Canada that their skills are not transferable, or
right.
they have they may be a doctor, they may be highly educated, but they haven't passed the local bar exam or the medical board exams. How do people get around that? How do they deal with that?
Well, it is a challenge, and I mean, there have been more initiatives coming into force that allow for the better transition of people and having their academic credentials evaluated and assessed, and for more integration into the workforce. So, I mean, it is a concern. I mean, I myself, a lawyer in California, had to go through the process to qualify here, even though I'm a dual citizen. So that definitely poses a challenge, but there are more programs coming into force to allow for the better integration of those people into the workforce.
So it's a matter of changing the restrictions, or changing what's necessary, or because people say, well, you're not diluting the requirements, are you?
Well, no, it's a combination of recognizing credentials and people getting the required education and training they need to, be able to integrate into the Canadian workforce.
Okay. So let's talk a bit about what happens when businesses don't comply with the temporary foreign worker rules, and they hire someone who doesn't have the proper permits. It does happen. What are the potential penalties?
Well, that's one of the reforms. So the government is definitely, tightening up on employers that don't comply with the requirements that are imposed on them when they initially apply. Like, I've had a client call me in a panic and say, oh my goodness, I just realized that an employee that we had, we thought that she had a valid work permit, but in fact she didn't. And I mean, that is very serious. there are good faith provisions in the legislation, that can allow the employer to explain their situation. And, if there was no, unlawful intent or intent to deceive, then, it might be okay. But there is going to be a process involved. And right away, the employer in that case should, tell the foreign worker that they can no longer work and they need to straighten out the situation before moving forward.
What about the worker? Are they potentially liable?
Yes. So the worker, could may have to leave Canada and be prevented from coming back for a period such as a year or so. And so there's implications. And I mean, for the employers that, willful blindness is not necessarily an excuse, and they can be penalized, like fines for having a worker without a work permit working is about $50,000 plus a term of imprisonment. And for more egregious behaviors, the fines, can increase and the jail penalties can increase as well.
I appreciate you coming in this morning. If people want more information, how do they get a hold of you?
Yes, so they can contact me through my website at www.boughtonlaw.com, and I would be happy to help them.
And you can find out more. You can go to our page at cknw.com/BoughtonLaw and find out some more information there as well. Nice to see you. Thank you for coming in. We appreciate it.
Thank you so much for having me, John.